Hello everyone, my name is Disha Mehta, a legal intern at LEXIS and Company and a law student at Gujarat University. And today we are going to talk about various types of deeds. So first let us start with the term deed. What do you mean by the term deed? So a deed is an instrument returned, signed and handed over by one person known as the grantor or seller that transfers the ownership of the real property to another person known as the grantee or the buyer. In other terms, a deed is a signed legal document that grants the guarantee of certain rights over an object, allowing them to own it. A deed is any written legal instrument that confirms and transfers an interest, right, or property from one person to another. Simply speaking, a deed is a form of legal instrument that consists of legally binding commitment to accomplish something. The most common application of deed is to transfer property of ownership, whether it is movable or immovable, between two parties. The only significant difference between a deed and an agreement is that consideration is not required for a deed to be legally binding, and a deed must be executed in writing. The five essentials of legally valid deed are: first, it must be in writing. The next one is it must be signed. The third is it must be expressed to be a deed. Fourth is it must be witnessed by at least one such person who is not a party to the concerned deed. And the last is it must be delivered to the other party. So what are the types of deeds? So let us start. So the first one among them is the conveyance deed. So a conveyance deed is a legal instrument that transfers ownership of property from one person to another as a gift or an exchange, a lease or mortgage, among other things. A conveyance deed can also be referred to as a gift deed, mortgage deed, lease deed or sale deed. In its broadest sense, this refers to any property ownership transfer for the buyer's benefit, such as gift, mortgage, lease or exchange. A sale deed is a legal document used to transfer ownership of a property through a sale. All conveyance deeds are all sale deeds, but not all sale deeds are conveyance deeds. So this is the type of conveyance deed. The next one among them is the grant deed. A grant deed is a legal document that transfers ownership of a property from the seller to the buyer in exchange for a set sum. It ensures that seller has complete ownership of the property being free and clear of all debts, but it does not include a warranty for title flaws as the warranty deed does. So this is the type of grant deed. The next one is the quit claim deed. So basically a quit claim deed is typically executed when both parties have some form of relationship with one another, such as family members, divorced couples and friends. It is generally performed by people who are familiar with one another. This type of deed is designed to transfer any title, claim or interest in the property that the grantor may have, but it makes no assurance that such title is legally legitimate. So, in a sense, this sort of deed provides for the straightforward transfer of property rights and claims to another party with the majority of time no money exchange and no promise or no guarantee. So this is the type of quit claim deed. The next one is the trust deed. So a trust deed is a type of transaction in which property is transferred to a trustee to secure a debt, such as a promissory note or a mortgage. In the event of default on duty, the trustee has the power to sell the property. So this is the type of trust deed. The next one is the court order deeds. So these types of deeds are carried out without the owner's agreement due to a court order. These deeds are created when the sellers are unable to pay for the house and are thus executed without their agreement. The exact price of the real estate is mentioned in advance as a consideration in this court's order documents, which is a unique feature. So this is the type of court order deeds. The next one is the type of lease deed. So basically, a lease deed is a legal document or instrument required for the performance of a lease. Essentially, it certifies the lessee's ownership rights and interest in the leased property. The next one is gift deed. So, a gift deed is a legal document that reflects the transfer of gift. Under Section 122 of the Transfer of Property Act 1822, the donor can freely transfer an existing movable or immovable property to the donee through the use of a gift deed. It is legal only if given out of natural love and affection without expecting anything in return by a family member or a friend to another family member or friend. So this is the type of gift deed. So these are the types of deeds which we have discussed, and the rest of the types we will discuss in the next part of the video. If you have any doubts regarding any of the deeds, then please do write down in the comment section below. And also, if you have any doubt regarding any previous of the topics, then please feel free to write in the comment section down below, and we would be happy to help you. Thank you.